I'm George Curtis. Welcome to It's Your Law. Each week it's my privilege to bring guests that teach me about the law, how it's supposed to work, how it sometimes works, and how it usually doesn't, and what we can do about it. What's important about these particular sessions I have with you, the public, is the guests that I'm able to bring. Without those guests, this could be a long half hour, but I'm going to give you a fast one today. This guest is interesting, and he's got something to say, and it's something that's going to impact your life and the life of your family. His name is Scott Ceman.
Morning, George.
Scott, it's great to have you on the show. You've been with the District Attorney's Office. You've had private practice. You finally made a decision to leave the District Attorney's Office when you were the top dog and go on the other side of the fence and represent people who are accused of the crime. I'll admit that I was encouraging you to leave the District Attorney's Office because I've respected your intestinal fortitude, sometimes known as guts, and your willingness to go to trial, which is important. I think that we have lawyers that will go to trial and fight for their clients. Your willingness to work, and I'll be frank, I tried to hire you, but so you followed half my advice. You quit, you quit the DA's office, but you didn't come to work with George. Why don't you tell us what you did?
Well, I appreciate the offer, George. I've told you that, but I did. After 14 years of public service with the District Attorney's Office, I felt like I'd done about all I could do for the interests of society. When you're a prosecutor, you don't really represent the victims as many people think. You represent society as a whole. And a lot of people don't understand that that also includes what's the best interests of the defendant, rehabilitation, and to make sure there's no recidivism. And over the years, the last 10 years or 9 years, I supervised all the attorneys, and I was the head of the Violent Crimes Unit, and I initiated a lot of programs in the county to combat elder abuse and child abduction and things of that nature. And it got to the point where I decided that people charged with crimes and even more people accused of crimes need really a powerful advocate out there. And it was time for me to start representing individuals who are accused not only of crimes, but also of civil wrongs, and represent them in the litigation field.
Let's take a minute and introduce Scott Ceman to our audience. You have an interesting background. You got out of high school and decided to jump out of airplanes.
I did.
And you've been jumping into space ever since. Tell us a little bit about your career.
Well, like a lot of farm kids brought up in the 70s or 80s, you look to the military to get away and do something different. But yeah, I was raised on a farm in Waushara County, just about 20 minutes outside Oshkosh. And after high school, I joined the Army, and I served 4 years as a paratrooper in the 82nd Airborne. And then when I got out, I didn't go to college right away. I worked as an iron worker for 7 years in the area. And during that time, about the last 4 years of that, I was doing a lot of night work. And then I got a letter from I think it was from the VA, letting the clock was ticking on the GI Bill. So I picked up a bachelor's degree, and then ended up going to law school. And that was the winding road that took me to being an attorney.
And when you came out, you didn't make just one stop either. You had varied experience. Tell us about it.
I did. When I got out, I initially took a position with a firm in Berlin, Shire Law Office, and I was focusing mostly on contract, property litigation, things of that nature. But I also started as a part-time district attorney in Waushara County, and I got to experience both sides. And at that time, I was more interested, I think, in the action and the litigation that came with being a district attorney. So then I became a full-time prosecutor. And that's what I did for up until this year.
And how did you end up in Oshkosh with the DA's office here in Winnebago County?
It started as I accepted a special prosecution when I was a prosecutor in Winnebago, Waushara County here, and I handled the case for the district attorney's office, and apparently they must have liked it because then they offered me a position over here in 2007 as the Domestic Violence Prosecutor, so then I came over here from Waushara.
Well, as you probably know, and I'm sure your wife has told you many times, you're a rare bird. You, you are a trial lawyer who actually tries cases. We see on television these people who, most of them are Hollywood actors who aren't even lawyers, but people advertising that they're big, tough combatants who go to jury trials and get money or otherwise represent their clients. But really, there are fewer and fewer trials. I doubt that there are more than 2 or 3 lawyers in Winnebago County who have had 100 jury trials, and you and I are 2 of them, maybe all of them. Mm-hmm. How rare is it that people actually are willing to go and take the gamble, run the risk of failure, being humiliated, disappointed clients, and you get your answer from a jury. You won or you lost. There's no way to muddy it. How do you feel about that?
You know, I explain to a lot of my clients that there's really 2 aspects to being a trial attorney. The first part, when you retain someone like myself, is you need somebody who's got the knowledge and the ability to do the legal work. That's where all the real science of law comes into place, is leading up to trial, the motion work. And once you fail to come to a resolution, then you look at phase 2, really, which is the jury trial. And at that point, it's more of an art. And if people aren't comfortable getting up on the stage, which most attorneys aren't, they like to stay in their office for the most part. But you got to put yourself out there in front of a jury and the judge and perform. And it's also the rules of evidence come in, and that's probably one of the more complex areas of any field of law, is when you get to the rules of evidence and being able to be proficient with those and be proficient with them on the go. You don't have time to open up a law book. You'll see a lot of attorneys who don't try a lot of cases bringing those statutes with them to trial, and it's too late for that. That's what I always think, because you're not going to have time. The objections come fast, the rulings come fast, you don't want to keep the jury waiting, so it takes a lot of experience. And one of my first bosses as a prosecutor told me it takes about 24 jury trials to get comfortable. And, you know, he's probably right. Until you're comfortable performing in front of a jury, performing in front of a judge, and performing in front of your client, and have that understanding of the law, there's not very many people. I think I heard a statistic once, of all the attorneys out there in Wisconsin, I don't know, there's 23,000 or something like that. I believe it was 7% at most actively try cases across the state.
Let's take our first break. And when we come back, I'm going to ask you what the public should expect of a trial lawyer when they have some reason to believe that someone close to them, including themselves, is suspected of having done some illegal activity, and what should they do before they talk to the police? We'll be right back. People often ask what they should do if they're in a car accident. Turn off your car. Put on your flashers. Check for injuries. Check others for injuries. Call 911. Give honest, brief answers to the police officer. Call your attorney from the scene of the accident. Let your attorney deal with the insurance companies. Then head to the hospital and get checked for injuries yourself. If you take these precautions, you're off to a very good start. Then follow up with your attorney the next day or 2 for the next step. Welcome back to It's Your Law. I'm George Curtis. My guest is Scott Ceman, who's been top dog in the Winnebago County District Attorney's Office for a substantial period of time. He's developed a real reputation as being a fighter and a wise, successful, professional guy. And he's made a decision that he's going to have his own practice and he's going to represent people who are accused of crimes. Now, nobody's better qualified to do that than a prosecutor, because you've seen it come from the other side. You know what goes into an omelet. But at the same time, it's an adjustment. It's a mindset change. And you have to look at it from the standpoint of what is it like to be the accused. When somebody feels that the police or a bank or some other institution is looking at something they did with scrutiny and they may have concerns, obviously you and I agree, they hire a lawyer. They hire a lawyer who's qualified to do this kind of work. What should they expect when they call Scott Ceman?
They should expect an attorney that's not only competent at trial, but is competent on the front end to help them potentially avoid a trial and even avoid charges depending on where they're at. So if a person becomes aware that an accusation's been made by somebody, whether it be a person in the community or law enforcement, they should immediately contact an attorney. And because we can advise them, I can advise them of their rights. They have constitutional rights to remain silent, constitutional rights to be secure in their homes and in their possessions, and constitutional rights to counsel. And when somebody is charged with a crime, they should expect on the front end that they'll have an active investigator working on their behalf. I think that one of the biggest advantages of having a former prosecutor, an experienced one, with the years I have representing them, is that as much as that I'm a skilled trial attorney, but I'm a skilled investigator. I'm a forensic interviewer, certified in that, and that's relevant because a lot of these accusations come in the verbal form, as you know, and being able to pick apart and find deception and inconsistencies is what a forensic interviewer does. But I'm also an experienced investigator. A prosecutor comes to a person's case doing everything forensically. We don't just read the reports or go through the statements. I know how to forensically analyze, and there's a big difference there in picking apart the numbers from bank records, picking apart statements and forensic interviews of people making accusations. And more relevant in most cases is being able to pick apart what the police did and find those constitutional violations that ultimately can lead to suppression. I spent every year a significant amount of time training law enforcement from all over Winnebago County and the area on Fourth Amendment issues, Fifth Amendment issues. So I'm aware of the common mistakes made. I'm aware of the common misconceptions law enforcement have. That of things they can do that really they can't when making contact with and taking a person into custody, speaking with people who an allegation has been made against, and these things often lead to suppression.
In the real world situation, these things come up. A business person calls and says, I've been called into my bank to an audit committee. I don't think I've done anything wrong. But what should I do? What are my rights? Or I've got a call from a police officer, says I'm not charged with anything. He or she just want to talk to me. What should I do? Somebody's at the door. They say they're not looking for me. They're looking for my son. I want to look out for my son. He's actually in the back bedroom and the light's out. What should I do? Those are the kind of real world, instantaneous issues that criminal trial lawyer is confronted with, because it's what happens before you get to trial that determines what happens after the trial.
Yep. I think I would tell them, well, first thing you should do is call me, because in all those situations, you should have representation. For the person going into the bank audit, depending on the situation, there could be what we call Garrity issues, which you're well aware of, and statements that could be made by them that could put them in jeopardy of a criminal prosecution, much less civil ramifications as well. For the person that the police want to speak with them, enter their home or speak with them about their son, at the same point in time, they should still contact myself, because you can advise them of what the constitutional rights are: their right to remain silent, the right to request a warrant, which would basically be the police to get probable cause first, instead of you inadvertently giving them probable cause to go farther into your home, into your son's life, into your son's future. So that's where most of the legal work begins proceeding up to trial, is the things that happen in those early stages of an investigation.
Absolutely. Waiting too long is the number one mistake that most people have. Secondly, talking too much is the number two mistake, at least. Now, I've stopped doing criminal work 20 years ago, but I always gave my clients 3 bits of advice. Shut up, shut up. You can guess what the third one was. Has that changed?
No, it hasn't. I mean, it's a fundamental right since the founding of this country is your right to remain silent. And you do not want to forfeit that at any cost. You can always talk later, but you should make sure you have representation on the front end. And the things you discuss with your attorney are completely confidential. So you can only have that right to remain silent until you forfeit it. You can forfeit it later if you want, on the advice of counsel.
Excellent advice. This is a good time for our second break. We'll be right back. Welcome back to It's Your Law. I'm George Curtis. Scott Ceman is my guest. He has been very effective as a prosecutor in the district attorney's office. He followed my advice, but just half of it. I told him he should give up that and come to work on the other side representing the people instead of the government, and he should come to work right here at our law office. Well, I must have talked too long, and he fell asleep during the second half of the course. So he left the district attorney's office, which is no small move. There's a lot of experience, security, income, certainty, and recognition with that job. It wasn't a bad job by any means. And now he's on the other side. He's representing the public. He's representing all of us. Interestingly, now he's got a problem called making a living. And so we have to let the people know how they can reach Scott and what he can do for them, what it's likely to cost them, and if they really qualify as indigent, which a great number of people in this state do, what our public defender program says. That's a long question, Scott. I'm sorry. Start where you want.
No, that's fine. There's a lot. I'll pick up where you left off. People who are indigent have 2 options depending on how indigent they are. If they're charged with a crime, the state will provide them a public defender. There are a number of us private practice attorneys out there that will accept appointments from the public defender to represent these indigent people. And when I went into private practice, I agreed to do that, and primarily because of all the private practice defense attorneys out there that are willing to take public defender cases, there's only a handful of us that are actually qualified to handle the highest level felonies, the Class A, B, and C felonies. I was told there was approximately half a dozen in the entire state, and I made that qualification based on the number of homicides I tried as a prosecutor. So it was really an eye-opening experience. Just the number of people in this state sitting in jail waiting to get to court who have been accused of these higher level felonies who cannot find an attorney because there's nobody close, available, or willing to represent them. So I've taken a number of those cases, and a lot of them are in the northern counties and around the area. And one example, after taking a case, the very next week, I got the felony charge thrown out at the preliminary hearing, and this poor gentleman been sitting in jail for weeks, just waiting to get that opportunity. So if people make too much money to qualify for the public defender's office, but not enough to retain their own counsel, then they can petition the court to appoint them an attorney. And those cases, the court will appoint somebody from the local bar that's willing to take court appointments, and the person has to agree to pay back the county at a rate of usually $50 to $100 an hour. And if somebody doesn't qualify for that, then fees are typically negotiable, depending on the charge. I think what's important for people to understand is whether I represent them as a public defender case, whether I represent them as a county case, or as a private pay walk-in-the-door case, the representation level is the same.
But how do they reach you? Now, some people will be exposed to you because of their prior knowledge, and this program hopefully will be a reminder. Oh yeah, I remember him. He ran for judge and almost made it in a very tight race. I'm glad you didn't, incidentally, but that's my opinion. I think what you're doing here is more important. I really honestly do. But how do people get a hold of you? Is there a number? Is there an address? Something they can keep so that, hey, I want this Scott Ceman guy in my wallet.
Sure. Well, I have a website. It's cemanlaw.com. That's CEMAN law.com. My phone number is 920-573-2336, and I can be reached by email as well at scott@cemanlaw.com. And I'm located inside Olson Legal Group at 146 Algoma Boulevard here in Oshkosh, and we also have an office in Berlin that's available by appointment.
And you travel the entire state representing people?
I do, yes, and primarily around northeast Wisconsin and the western part, but absolutely.
Would you agree with me that if anybody has even a little concern that they may have themselves or a family member with a possible legal problem, an ounce of prevention is worth the cliche pound of cure?
Absolutely. One thing that I've successfully done for a couple clients already is pre-charge negotiations with the district attorney's office, because what a lot of people don't understand is after they've been approached by the police, they don't know where their case is at, if there is a case, because the police can't charge you. They can only refer charges to the district attorney's office and ask that they charge you. And so early intervention, not only between a client and the police at the front end of the investigation, but if that contact's already happened, which many times unfortunately it has, then intervention on behalf of a client in between the police and the district attorney's office.
2 points I think you've made very clear. Number one is the sooner the better that you contact an attorney, the more that attorney can do for you. And the second one is shut up unless you're talking to your own attorney.
Absolutely. As I said before, once you waive your right against self-incrimination and start making statements, unless there's a constitutional violation that led to your failure to remain silent, and a lot of the times that regards around custodial interrogation. Were you in custody at the time that you gave up your right to remain silent, and were you being interrogated? And those are suppression issues, but you're far better off if before we have to start breaking down that type of legal analysis of what occurred during your contact with the police, that you have an attorney at your side first.
And a skirmish with the criminal justice system isn't just something that happens to bad people. It can happen to anybody. And it has happened to some very, very successful, great people who went on to hold public office or run businesses or run charities or things like that. Nobody should be embarrassed about. I think I'll call Scott Ceman and see what he thinks of this.
Absolutely. There's so many different crimes out there. People don't realize that, a lot of people think that if I don't do something intentionally bad, I can't be charged with a crime. There's negligent crimes, there's strict liability crimes, there's no intent whatsoever. There's reckless crimes. So it's not just intentional crimes. People, unfortunately, nowadays can find themselves charged with simple mistakes in accounting, in driving, in childcare, in so many different areas, things they get into on the internet. I mean, that's the state of the criminal law these days.
And the statistics tell us that many of these people are victims themselves of the crime of being poor, the crime of being foreign, the crime of being uneducated, the crime of being of color. So we need people like you and hopefully like me that want to improve the civil justice system so it really is the same for all of us. And I know in you they've got a champion. I still think you should have come to work here, but thanks for being on the
Well,
show.
I appreciate it, George. Thanks.
Thank you. And thank you, ladies and gentlemen. Scott Ceman has had an interesting, challenging life and is just beginning. Graduating from high school, he joined the paratroopers. After being a paratrooper, he was a steel worker. After being a steel worker, he decided to use the GI Bill and become a lawyer. And what a lawyer he became, one of the top prosecutors in the state. After representing the government successfully and having that security, he decided to switch sides and represent the public, you and me. That's an honorable switch. It takes the same kind of guts as jumping out of airplanes. I'm proud of him and I recommend him to you. I'm George Curtis.